Yes.
It's not quite 4:30, but given the quiet that has fallen over the room, I'm Robin Wilson. I'm the Law Review Advisor, and I have the distinct pleasure of introducing Hal Clark, who is the Deputy General Counsel at Wells Fargo in Charlotte, North Carolina, but a little closer to home is the President of our Law Council. So, Mr. Clark.
Thank you very much, Professor Wilson. It's always a pleasure to be at WNL, particularly back at the law school, so thanks very much for this opportunity. I think we have a treat this afternoon, and this is a tradition that I think WNL should be proud of honoring the best in a group of best. Here in the Law Review, we have two outstanding examples of legal scholarship, and I'm going to go out on a limb and talk a little bit about legal scholarship, which is a very dangerous thing for a corporate lawyer to do, but bear with me. I think some of the things you see in excellent legal scholarship is not only excellence in research, in thought, and analysis, and written expression. It also relates to topics that matter to people. And lastly, it introduces new ways of thinking about, looking at, or solving relevant problems. I think the program today illustrates excellence in legal scholarship. We have two presentations relating to very timely and very important topics to different sets of people. Luke, in his presentation, will take a look at the Dodd-Frank Act and an obscure, somewhat important, and we'll find out how important, part of the financial services world with the regulation of hedge funds. Claire Hagan will take a look at sheltering psychiatric patients from the DeShaney storm, which takes a real look at a difficult problem within jurisprudence in determining what duty does a state owe patients who are there voluntarily. And I think her analysis, like Luke's, gets at the reality of both of these timely topics. Our presentations this afternoon will be set out in this order. Professor Jost will introduce Claire, who will then make her presentation, and then Professor Susan Stefan, who's a visiting professor today, and Professor J.D. King of the WNL faculty will give commentary on her presentation. We'll take a short break and then come back, and Professor Bruner will introduce Luke, who will then make his presentation, and we will have commentary by visiting Professor J.W. Barrett and WNL Professor Lyman Johnson. So please join me in congratulating the two presenters today and in welcoming our visiting commentators this afternoon.
It is with great pleasure that I introduce Claire Hagan. Her note, Sheltering Psychiatric Patients from the DeShaney Storm, and those who will comment on it. Over my decades of teaching, I've had the honor of supervising many law review notes. I do not believe I have ever had a student who took this task so seriously and worked so hard as Claire. Week after week, she came by my office with drafts of the note or drafts of pieces of the note asking for help as the note progressed, and they just got better and better. I was only one of her note advisors. I think she had two others as well. So she worked really hard. The product of this effort, examining the rights of voluntary mental patients, the note that she will present today, is very good. Claire graduated from Notre Dame in 2005. In 2006, she received her Master's of Social Work from the University of Michigan. She worked for the next 4 years at the Johns Hopkins Hospital on the inpatient psychiatric service in the department, and the inpatient schizophrenia service in the Department of Psychology. She knows whereof she speaks when she talks about the rights and struggles of mental patients. Two commentators will respond to Claire's note. The first is our own J.D. King. Professor King is the director of the Washington and Lee Criminal Justice Clinic and an associate clinical professor of law at the law school. In addition to designing and supervising the criminal justice clinic, he teaches in the areas of criminal procedure, evidence, and professional responsibility, and writes about criminal defense and prosecution ethics, as well as the right to counsel. J.D. has a BA in History and Religious Studies from Brown University, a J.D. from the University of Michigan Law School, and an LLM in Advocacy from Georgetown University Law Center. Also commenting is Susan Stefan. Ms. Stefan is a faculty member visiting faculty member at the University of Miami School of Law. She is one of the country's most highly regarded experts in mental disability law. From 1986 until 1990, she worked at the Mental Health Law Project, now the Bazelon Center for Mental Health Law. More recently, she was an attorney with the Center for Public Representation in Massachusetts, where she directed the center's National Emergency Department. This department provides consultation and technical support on issues relating to the treatment of people with psychiatric disabilities in emergency department settings and community psychiatric crisis alternatives. Prior to working at the Center for Public Representation, she taught disability law and mental health law at the University of Miami School of Law from 1990 until 2001. She has written 3 books on mental health law issues, as well as chapters in other books and numerous law review articles. She has also litigated cases involving the rights of mental patients and has served as an expert witness in other cases. She served as an expert consultant to the President's New Freedom Commission on Mental Health and to the Institute of Medicine for its publication, Improving the Quality of Healthcare for Mental and Substance Abuse Conditions. She is at work on a book right now to be published by Oxford University Press on U.S. social and legal policies concerning suicide. Claire's note addresses the question of what affirmative duties are owed to voluntary mental patients by the state. A traditional answer to this question is that the state owes duties to protect involuntarily committed patients, but not voluntary patients. Claire's note argues that this is not a complete answer. In some instances, states must protect voluntary patients as well, in particular when they are functionally in custody or where the state creates or increases the threat to the patient. I commend this note to you and look forward to Claire's presentation at this time.
Thank you. I want to start by thanking Professor Jones for the introduction. It's very nice. And for advising my note. I don't think anyone would be surprised that he was just a complete rock star as a note advisor. And I really appreciate all the help that you gave me all year. Second, I'd like to thank Professor Stefan for coming all the way from Miami and leaving her family, although I guess I could have come. And Professor King for coming, even though your family's here. It's taken a lot of time and it helped me with my note. I really appreciate that. And finally, I want to thank some friends of mine who have come here and taken off work. Some of my friends from Johns Hopkins Hospital, and then just walked in Doug Amar from Atlanta, who's an alumni of the law school and runs the Georgia Justice Project in Atlanta. So I also want to thank the Law Council for sponsoring this award, which I'm very honored to have won. Surprised and blessed. And I guess my only advice I would give to the staff writers, I know last year we received some really good advice. The only advice I have is that I wrote about something I really cared about, and that made it a lot easier when it comes to, February, and you're writing your 300 footnote. It's nice if you really like your topic. And I followed some advice from my father, from when he wrote his student note back in the mid-70s, and we listened to Bob Dylan over and over, and so did I, and it made it a lot better. Okay. So as Professor Jones mentioned, my note covers the intersection of constitutional and mental health law in state psychiatric hospitals. And to illustrate what I'm talking about, I want to start with a story, which I'm borrowing from an 8th Circuit case called Kennedy versus Schaefer. So Kathleen Kennedy was a 15-year-old girl with severe depression. She was treated at a private facility, but she used up all of her inpatient days. And so she ran out of insurance coverage, and so she had to go, or she didn't have to, but she was encouraged to go to a state hospital where they would only be charged based on what they were able to pay. Now, Kathleen could have been admitted. You can be admitted to a hospital in 2 ways, either voluntarily or involuntarily. And I'll talk a little bit more about that in a minute. So the hospital that Kathleen was at, the private hospital, said, you have this choice, but if you don't go voluntarily, we'll probably commit you involuntarily. Like, you have to stay in the hospital. You're not ready to be discharged. But Kathleen's parents, who were her guardians, signed her in as a voluntary patient. So she went to Hawthorne, which is the state hospital. After several months at the state hospital, she remained suicidal. She wasn't really responding to treatment. And she was on suicide precautions, which meant that a nurse would have to keep her within their eyesight at all times. But one evening, the nursing staff was short, and they didn't find a replacement nurse to cover the shift. And so that evening, the nursing staff did not keep her within eyesight. And after 2:30, nobody saw her for about 3 hours. And that's when they found that she had hanged herself in her room with a bedsheet tied to the air vent. So Kathleen's parents sued the hospital, and they argued that the state had been under an affirmative duty requiring it to proactively protect her from harming herself because they knew that she was at this risk. And the state had violated its affirmative duty, which led to Kathleen's suicide. Now, to a court, the fact that Kathleen had been a voluntary patient will be either a determinative fact or the determinative fact on the question of whether the state actually owed her a duty and whether there was a duty to be breached. And this is the question that my note addresses, is can a state ever owe affirmative duties to voluntary patients like Kathleen? Okay. So I'm going to give an overview of my note. I'm going to try not to get too into little details. And this is kind of the overview of what I'm going to talk about. I'm going to talk a little bit about substantive due process and affirmative duties, a little bit about mental health law, a circuit split, which was what had kind of drawn me to this topic in the first place, and then my argument in response to the circuit split, and then the analysis that I would propose. Okay. So first, substantive due process. The question that I'm asking is about whether the government owes affirmative duties to an individual arising from the substantive due process clause of the 14th Amendment, not tort law. And so substantive due process is one of the more amorphous constitutional rights. We don't really know exactly what it means, but the law is clear that one thing substantive due process does protect is the right to control your own body. And to enforce this right, you can bring an action under Section 1983. Which is the vehicle to get yourself into court. But winning on a Section 1983 claim based on an affirmative duty argument is very hard. The doctrine is limited, and it generally restricts government action. It rarely mandates the government to do something. And so it's a rare case when the government can be held liable for not taking an action. Courts often describe substantive due process as a charter of negative liberties, and Judge Posner gave this explanation, which is kind of cited over and over in court opinions. But I want to emphasize that while it's very hard to make out this claim, it's not impossible. Sometimes the state does owe you a duty and has to protect you. For example, if you're in prison, the government needs to make sure that you're safe and provide some medical care. And in the state hospital setting, the most important case is Youngberg versus Romeo, which was authored by the school's patron saint, Justice Powell. I heard that today. I liked it. So Nicholas Romeo was a 33-year-old man who was severely mentally retarded, and he had the IQ of an infant. He had always lived with his family, and his parents took care of him, which was difficult because of his mental disability. And after his father died, his mother wasn't able to take care of him by herself. So she petitioned the Pennsylvania court, and he was committed involuntarily to Pennhurst, the Pennsylvania psych hospital that had other roles in constitutional law. Like Kathleen, things did not go well for Mr. Romeo at the hospital. The staff failed to implement its treatment plan, and he was injured on 63 different occasions, at least some of which were self-inflicted. So Mr. Romeo's mother sued the state, alleging that the hospital had violated an affirmative duty to protect and treat her son. It's the same claim that Kathleen's parents had brought. Writing for the court, Justice Powell held that involuntarily committed patients are owed affirmative duties, including reasonable care and safety, and so they were able to hold the state liable. In reaching this conclusion, Justice Powell analogized psychiatric hospitals to prisons, reasoning that if the state can't constitutionally hold a criminal in unsafe conditions, then it certainly can't hold involuntarily committed patients in unsafe conditions. And patients can't be punished at all. They haven't been convicted of anything. The court did not address whether voluntary patients enjoy similar protections, even though at the same time a circuit split was already brewing on this question. Then, in 1989, the court handed down its most important affirmative duty case, DeShaney. He's a little blurry. He's a really cute little kid. So DeShaney is not about mental health patients. It's about a 4-year-old boy, Joshua. And to make a long and very sad story short, Joshua was being physically abused by his dad. The Wisconsin Department of Social Services was aware, and they would send a social worker every month to the house to check on him. But over a period of a little more than a year, Joshua kept showing up at the emergency room injured. And the hospital kept reporting the injuries to DSS, and DSS kept just sending the social worker. Finally, one day, Joshua showed up at the hospital in a coma, and emergency surgery showed that his brain had been severely damaged from sustained blows to the head over a long period of time. He was now severely retarded and will probably spend the rest of his life in an institution. So Joshua's mom sued Wisconsin DSS and alleged his affirmative duty, that the state had an affirmative duty to protect him because they knew that he was they knew the danger that he faced. But the Supreme Court said no. Chief Justice Rehnquist authored the majority opinion, which sharply cabined the substantive due process clause. And he started with some basic principles. First, that the due process clause limits the government. It's a basic federalism point that the due process clause doesn't give the government more power or require it to serve the citizens. And because the government has no duty to protect, it can't be held liable for failing to protect. Now, DeShaney was not a unanimous decision. Justice Brennan wrote a strong dissent where he criticized the majority's analysis, although he agreed with the majority's basic premise that as a general rule, there's no duty to protect citizens. DeShaney's majority has been received a pretty negative reaction from scholars, but remains the principal case on affirmative duties under the substantive due process clause. And while DeShaney's significance rests largely on how it limits affirmative duties, the majority said that affirmative duties do sometimes exist, although in limited contexts. So as interpreted by pretty much every circuit, since the decision came down, DeShaney provides 3 exceptions to the no duty rule. The government is obligated to protect you if it takes formal custody, meaning if they put you in prison or pretrial detention, or if they involuntarily commit you to a hospital. If the state takes functional custody, restraining your liberty so that you can't protect yourself, or if it creates or increases the danger. And Judge Posner, he has articulated this last exception in a variety of very vivid ways. Most commonly cited is that if the government throws you into a snake pit, it has to protect you from snakes. So DeShaney can be seen as a general no duty rule, but with 3 exceptions. And with that, I'm going to shift to mental health law. People needing inpatient psychiatric treatment can be admitted to a psychiatric hospital either voluntarily or involuntarily. And this is a state law issue, and states have somewhat different standards for what's required to involuntarily admit someone. Usually they require that you are sick and that you pose a danger to yourself or someone else. Voluntary admissions involve a person consenting to admission. These are the patients who have signed paperwork and been admitted voluntarily, and this is what my note focuses on. But I want to make just a few points about what voluntary means in a psych hospital. First, I think as everyone knows, in a psych hospital, the doors are locked, and so you need a key. And so whether you're voluntary or involuntary, you're physically restricted from just walking out the door whenever you want. Second, patients are almost always legally restricted from walking out the door. As a general rule, when a voluntary patient decides he wants to leave, The clinical staff can and sometimes must keep him in the hospital for another 48 to 72 hours to evaluate whether he actually needs to be held in the hospital against his will and whether they need to start involuntary proceedings. Now, state hospitals, courts disagree about what rights voluntary patients have, and this takes me to my circuit split. Now, as I said at the start, the circuit split is what drew me to this note, and generally the circuits are divided into two different camps on the affirmative duty question, whether affirmative duties are owed to voluntary patients. The first group of circuits takes a status-based approach. The first, fifth, and sixth circuits take this kind of narrow view of DeShaney. And basically their analysis, they ask whether the state has instituted involuntary commitment proceedings. And so this question can be answered pretty much by looking at the legal paperwork in a patient's chart. Did the patient sign a voluntary admission form? Or if he did, has the hospital initiated any procedures for involuntary commitment? And if not, then there's no duty, case closed. Another group of circuits take a more fact-specific approach, the 3rd, 8th, and 11th. The 11th Circuit, for example, has asked whether the state has exercised some requisite level of control and dominion over a person. The 8th Circuit asks whether the facts show that the voluntary patient was converted into an involuntary patient because of some control that the hospital exercised. So the paperwork might say voluntary, but the facts say you're actually involuntary. And the 3rd Circuit has a slight variation, asking whether the voluntary patient is free to leave. And if they're not free to leave, then affirmative duties are owed. So my initial inquiry when I started my note was which side of the circuit split is right. But my conclusion is that both the formal and the functional approaches are incorrect to the extent that they both apply a version of the same test. Is the patient voluntary or involuntary? I believe that this distinction is flawed in the state hospital context. And this afternoon I want to address two of the main reasons why. Competency and coercion. So first, competency. Voluntary admission, in order to really be voluntary, requires that the individual competently agree to be hospitalized by giving informed consent. Competency raises special issues in the psychiatric hospital. When a person is acutely ill with psychiatric illness, is that person competent? And I don't really know the answer. I don't think anybody really knows the answer. But the fact that it's so uncertain is the main point. For most of the 20th century, all patients were hospitalized involuntarily, and courts believed that the severe psychiatric illness rendered the person per se incompetent. The Supreme Court weighed in on this in a procedural due process case, Zinnerman versus Birch, and said that mental illness, by its very nature, creates special problems regarding informed consent, so that the hospital staff might not be justified in just taking the patient's proffered consent at face value. Patients requiring hospitalization may be legally incompetent because of their acute symptoms, but they might still be treated as competent and permitted to sign involuntary paperwork. And in that situation, a court can't really hang its hat on the fact that they signed in because the admission status doesn't mean very much if the admission was flawed. My second point is about coercion and what other outside forces are influencing a patient's decision to be voluntary. These forces might include professionals, clinicians, family members who say, you need to go to the hospital or else you can't stay at home, the legal system, or mental health policies. Some states have a presumption that you're voluntary. And in the hospital setting, the risk of coercion is increased. Psychiatric clinicians treating acutely ill patients approach coercion quite differently than con law scholars do. And coercion is a part of treatment. And that's kind of a separate issue that is whether coercion is a good thing or not in treatment is an entirely separate issue. But the fact is that there are coercive elements in inpatient treatment. So I suggest that courts should analyze affirmative duties, not looking at voluntary status, but just kind of straight up applying DeShaney, its general rule and its exceptions. In the circuit split, the courts are all looking at the patient's case in order to determine whether it fits within the first exception, whether the admission was voluntary or involuntary. But they don't really address the other two issues. I propose that when a patient sues the state on an affirmative duty-based claim, courts should start with a general rule that no duty exists, but then ask if the patient can make out that one of the exceptions applies. So first you would ask if there's been formal custody. Patients with a formal involuntary status, like Mr. Romeo, would fit here. And if they don't, then I think the court should move on to the other exceptions, which is what I think they haven't been doing. So second, if the patient is voluntary, you would ask whether functional custody has been made out. For example, if the patient lacked capacity when he signed his admission paperwork, if the staff coerced him into signing his voluntary paperwork, or if he requested to be discharged and was refused that right, or if there was an extremely high level of control being exercised by the state. And third, ask if the state created or increased the danger which led to the patient's injury. For example, if the hospital knew that the patient was actively suicidal, implemented a treatment plan and didn't follow through, like happened with Kathleen Kennedy, or if another patient inflicted the injury, should the hospital have reasonably foreseen that would happen and taken some measures to protect this vulnerable patient? In short, the state hospital can't become a snake pit. So why do I think this approach is better? Well, I have several reasons, and you can read my note if you want to learn a little bit more. First, it's a straightforward application of DeShaney. It applies the same test that courts apply in non-hospital cases. I don't think there's a reason that it should be a heightened standard for the hospital. If anything, I think it should be the other way. Second, this analysis protects the patient's rights and leaves the door open to bring Section 1983 claims, which in a 1983 claim you can get injunctive relief and litigation costs, which allows to be used as a sword to reform the state hospitals on a systematic level. Third, it's faithful to existing law and avoids arbitrarily expanding substantive due process. It just translates DeShaney into the state hospital context. Fourth, I argue that this analysis won't produce intolerable policy results, which I think is what's really driving courts to kind of keep the affirmative duty claims at bay. Now, some states argue that allowing more voluntary patients to bring constitutional claims will impose unsustainable burdens, and they'll have to stop accepting voluntary patients. But given the shortage of beds that the country currently sees, I don't think that really logically follows. Because if they stop taking voluntary patients, then all their patients will be involuntary, and then they would automatically have rights under Youngberg. Fifth, concerns about increased liability seem a bit overblown to me, because the affirmative duty claims are judged by an even more deferential standard than our standard medical liability cases. To be held liable, you'd have to substantially deviate from professional judgment rather than just deviate from professional judgment. And this is actually a standard that Justice Powell imposed in Youngberg purposely to protect hospitals from an uncontrolled tidal wave of new liability. So in the end, I encourage that the courts should keep the door open to voluntary patients and allow them the chance, not the guarantee, the chance to show that the states owe them an affirmative duty. And if the patient succeeds, then the parties can move on and get to the issue of whether the state breached the duty. And I suggest that sometimes we might actually want states to have to explain their actions. We might want, for example, Wisconsin DSS to explain why it didn't do anything to protect Joshua DeShaney. Recall that because there was no duty, no explanation was needed. And in the end, I think a more flexible standard, even though it requires a little bit more judgment from the courts, makes the most sense, especially in the state psychiatric context. Yeah.
Good afternoon. Thank you very, very much for the honor of inviting me here. I want to particularly thank Carney Simpson for all her work. She's continuing to work. The great irony of organizing a colloquium like this is the harder you work, the smoother it goes, the less people realize how much you work. And as a beneficiary of her efforts, I just want to say I know you did work very hard, and thank you. Thank you also to Laura Gass and Joe Black for shepherding me around and picking me up. And Laura Gass, thank you in advance for taking me to the airport. But special thanks to Claire Hagan for writing this article. This is a personal topic for me. I speak as somebody who has spent the last 30 years visiting over 50 institutions, hospitals, and wards all over the country, including, in fact, the ward from which Ms. Hagan's friends have come to visit today. Also, my very first published law review article, which came out around the time Ms. Hagan was entering first grade, was on Youngberg versus Romeo and negative and positive constitutional rights. So this is a great topic, and I'm grateful to Ms. Hagan for taking it on. The article is beautifully written, and it gets almost everything right. It's an accomplishment that I think Ms. Hagan, her advisors, and W&L have every right to be very proud of. I want to talk about the two parts of her article that I think are the best, and the only aspect of it that seriously troubled me, which, of course, she didn't summarize at all, so I'm going to have to summarize it myself. First of all, Ms. Hagan correctly attacks the voluntary-involuntary distinction as entirely meaningless and leading to outcomes that are both fundamentally unjust and downright irrational. In addition to the concerns that she highlighted about competence and coercion, something she mentioned briefly when she was talking about Kennedy versus Schaefer is that a number of patients who are committed as voluntary patients are committed against their will by either their parents or their legal guardians. They don't want to be there at all, but the law recognizes those kinds of commitments as voluntary. The MacArthur Study Group found that in more than 40% of so-called voluntary commitments, someone other than the patient initiated the admission. Almost 40% of voluntarily admitted patients said they believed they would have been involuntarily committed if they hadn't admitted themselves. 14% of voluntary patients were actually in legal custody at the time they admitted themselves to the hospital, and 10% reported being threatened if they didn't agree to voluntary admission. Furthermore, both case law and research supports my own 30 years of experience that drawing a distinction between legally voluntary and legally involuntary commitments doesn't even provide the virtue of clarity and certainty that you might think it did. So, for instance, in a case called Davis versus Rennie, and this situation is not uncommon, the patient signed the voluntary admission form. Typed across the top of the admission form was the staff note, patient refuses to sign voluntary, saying, I don't want to be in the hospital for a year. I had a client who signed a voluntary admission form and wrote across it, they forced me to do this. In Higgs versus Latham, a case that Ms. Hagan discusses, the Sixth Circuit, actually, this is quite an incredible case. The patient is actually legally involuntary. Because of a series of clerical screw-ups, the hospital she arrives at believes that she's voluntary, treats her as a voluntary patient, which includes repeatedly telling her she can't leave when she asks to leave. The Sixth Circuit finds that because the hospital believed she was voluntary, she's deprived of affirmative constitutional rights to safety and protection, and therefore has no claim even though she was raped. Now, mind you, this is the same Sixth Circuit that held that in the case of people with intellectual disabilities who were legally voluntary, that the functional custody analysis should be pursued. So if you have an intellectual disability in the Sixth Circuit, you are judged under the functional custody exception, whereas in Higgs versus Latham, the people with psychiatric disabilities were judged under the more strict formalistic division, raising what I would call Heller versus Doe issues, but that's a whole other constitutional case that we won't get into. But the main reason this distinction doesn't make sense is precisely what Ms. Hagan just said. No voluntary patient, whether they have psychiatric disabilities or developmental disabilities, intellectual disabilities, mental retardation, whatever you want to call it, no voluntary institutionalized patient can just walk out the door. I have 30 years of experience on this. These people get out when they are discharged by the hospital or when a judge orders their release. There is no difference in the experience of a voluntary patient and an involuntary patient in a mental hospital or an institution for people with mental retardation. Voluntary patients get restrained, involuntary patients get restrained. Voluntary patients get secluded, involuntary patients get secluded. They're both on locked wards. They both get denied so-called privileges of visitation and off-grounds release. There's no distinction in their experience of the almost complete loss of liberty, and there is no distinction in their ability to change the situation by leaving. Now, Ms. Hagan is also correct that the basis proffered by the majority in DeShaney for conferring affirmative rights on involuntarily committed people, that is, that their ability to care for and protect themselves has been removed by the involuntary commitment of the state. That's an illusion. As you said, Nicholas Romeo, Joshua DeShaney, no more able to care for themselves regardless of their legal status. But what she hasn't told you, her proposed basis, she changes the basis for these constitutional rights, and that's where I start having trouble. She proposes the patient's constitutional rights might arise from their mental illness. That's the only part of this article that I thought was misguided and not well supported, and I'll just go through 5 of these 7 reasons, which will be in my article, which you can read if you want to. First of all, it's way too broad. You cannot base affirmative constitutional rights on serious mental illness. That would logically give, she says, and I quote, patients' constitutional rights can logically arise from their illness rather than their confinement. That would actually give affirmative constitutional rights to protection and safety to about 10 to 15 million people, most of whom reside in the community, and would give them affirmative constitutional rights no one else has. Second, to base constitutional rights on mental illness would require judges to decide how serious the illness has to be to qualify for an illness-based protection. I can tell you from 20 years of litigation, judges would vigorously resist any call for them to engage in that kind of clinical effort, especially given the cyclical and very fluctuating characteristics of psychiatric disability. Third, to say that these constitutional rights arise from mental illness undermines Ms. Hagan's own excellent 3-step test, which is squarely and correctly based on confinement and functional custody. Nothing about her own test suggests it's illness-based, nor should it be. Fourth, despite her argument that there is a historic basis for holding the government responsible for the care of people who are seriously mentally ill, at least 8 circuits have held that commitment is not a traditional state function that would transform a private commitment into state action for Section 1983 purposes. Most important of all, this precise basis for constitutional rights has been rejected by at least 5 circuits. The 1st, 5th, 6th, 9th, and 10th, each of these circuits held the state cannot be responsible for dependence created by an individual's own condition, and that no affirmative rights can flow therefrom. But this is not a big deal. Honestly, it's not, because Ms. Hagan's 2 major contributions, first her critique, and second her test, do not rest on this argument about the basis for affirmative constitutional rights. And so I would suggest, respectfully, that just be, it wasn't in the presentation, not necessary. The critique is great, the test is great. I would say that her proposed test is one of the best, if not the best, that I've seen. I think that one thing you could do is examine some of the other tests that scholars, law students writing notes, other dissenting judges have come up with for deciding whether institutionalized patients have affirmative constitutional rights. I myself have looked at these. I think yours is great. I think it's one of the best. It's clear, and it can be followed easily. I also think that your discussion of the benefits, that very last piece of her presentation, of the benefits of your approach is one of the highlights of your paper. It's very well done and very persuasive. I think you would be benefited by clarifying the scope of your proposed test, so that initially when you present it, what you say is the functional custody, you look at confinement or functional custody, but then she pulls this really interesting move in her benefits of my proposal, which is different, where she brings in the Fourth Amendment test. Did they feel free to leave? Now, if you look at her proposal section, you would think it applies only to people who are institutionalized either voluntarily or involuntarily. If you look at the benefits section and you see the functional custody redefined as do they feel free to leave, that has a wider scope of some of the really interesting, more recent DeShaney cases brought by people with mental disabilities, which tend to take place in the kind of murky and complex no man's land between total institutionalization and total liberty. So that I found that broadening of the scope very interesting, worth putting into the test, the second section, the functional custody section. There were many, many things that Ms. Hagan did right in this article. One of the things I think also could be expanded on that is a really good thing is bringing in the tension with Zitterman versus Birch. That, I think, is a great thing. I wrote to a bunch of constitutional scholar friends of mine and said, hey, would Darrell Birch have been entitled to substantive due process remedies under DeShaney? Would this guy who was incompetent but nevertheless accepted as a voluntary, let's say he'd gotten beaten up, what's the analysis? Does he get protected under DeShaney? I think there's a lot to be done with that. I thought that was really brilliant. And I was told by Carney, and I promised her that I would keep to my time limit, because I know how tough it is to be the second person, and everybody there is sort of waiting. So I will close by saying, from my own heart, and on behalf of thousands of people who, despite being voluntary, very literally couldn't be here today, thank you and congratulations.
Well, I too want to say thank you for having me. It was an absolutely fantastic note, I thought, and whenever Claire appeared at my door, I was legitimately happy to see her and happy to discuss these issues with her, many of which were I was not intimately familiar with. President Clark kicked this off by saying that good legal scholarship covers topics that matter to people. That should seem obvious, but for those of you who spent the last 6 months up in the law review office sifting through articles, you may wish that more of the legal academy took that to heart. What we have here is a topic that matters greatly to a lot of people. And law fundamentally is about people, and everything a lawyer does, and every case a judge decides, and every piece of scholarship that a legal academic writes has the capacity to increase or to decrease human suffering, fundamentally. And it has the ability to affect people's lives in one way or the other. Ms. Hagan started with the story of Kathleen Kennedy. And Professor Stefan mentioned the story of Josephine Hayes. And in his article, Storytelling for Oppositionists and Others, Richard Delgado years ago described the power of storytelling in legal scholarship. And what he wrote was, stories, parables, and narratives are powerful means for destroying mindset. That is, the bundle of presuppositions, received wisdoms, and shared understandings against the background in which legal and political discourse takes place. Ideology, the received wisdom, makes current social arrangements seem fair and natural. Those in power sleep well at night. Their conduct does not seem to them like oppression. The cure to this, Delgado said, is storytelling. Stories can shatter complacency and challenge the status quo. They can help us understand when it is time to reallocate power. One of the things I liked about Ms. Hagan's note was the stories in it. That was one of the great accomplishments of this note, the stories she told about some of the most vulnerable members of our society. I wanted to start with a few stories. Part of the problem of going third is people take your stories. 2 of them, in fact. Ms. Hagan mentioned Joshua DeShaney, who is sort of at the heart of this story. Mr. DeShaney today is 33 years old, and he lives in an assisted living facility outside of Oshkosh, Wisconsin. He is partially paralyzed. He's got profound mental retardation and severe and irreversible brain damage. He was born to very young parents in Cheyenne, Wyoming. His father left the family before he was 1 year old, and his mother, when he was 14 months old, decided she couldn't take care of Joshua. She described it, she said, "I'm too young, too alone, and too poor." And so she sent him back to live with his father. When she was asked later, after all of this happened, why she did that, she said, "I wanted for him to have a nice little kid life, and I couldn't give it to him." The next couple of years of Joshua's life were almost unspeakably sad. It was repeated visits to the emergency room, repeated calls from the police coming to the house for calls of domestic violence, bruising up and down his body. The first time he went to the emergency room when he was just 2 years old, he had injuries on his face, scalp, spine, buttocks, thighs, penis, ankle, and heel. And the Department of Social Services opened a file on him that remained open in some way or the other for the rest of his childhood. As Ms. Hagan said, a social worker was assigned to visit the house once a month, and she did. During the last 4 months of his life, of his experience before the incident we're going to talk about, she never laid eyes on him. She went to the house 1 month and was told he was asleep, and she took no action to try to see him. She went the next month and nobody was home, and she didn't go back. She went the month after that, March 7th of 1983, and was told again he was asleep. That time she didn't try to wake him up, didn't ask to see him, but stayed in the kitchen with his father decorating a birthday cake for another child. And the next day, Joshua showed up at the hospital in a coma with irreversible brain damage. She was asked later about this, and she said, "I don't know why, but I didn't ask to see Joshua. Despite this overwhelming evidence of abuse, she didn't lay eyes on him for the 4 months before he suffered this irreversible brain damage." She later said, "I just knew the phone would ring someday and Joshua would be dead." And despite the extensive files that were kept on Joshua DeShaney, and despite the mind-boggling and infuriating negligence with which the state handled this, the Supreme Court denied relief, as Ms. Hagan said, because the state had, as they found, no constitutional duty to protect Joshua. Josephine Hayes, that Professor Stefan talked about, a 50-year-old woman living in a small town in Grayson County, Kentucky. Her husband, she had mental illness, and she was deteriorating, and her husband made the decision finally to involuntarily commit her to the mental hospital. The record is silent on what he went through and what she went through to get to that point, but you can imagine the agony and the self-doubt that Mr. Higgs went through to finally go to their local judge and say, "My wife needs to be locked up against her will." The judge ordered her involuntarily committed, ordered her detained in the local mental hospital until she could be shipped to the state mental hospital. She asked if she could drive down with her husband to the state mental hospital, and the authorities said no. She was then strapped down in the back of an ambulance, not allowed to sit up. She was restrained, brought down to the hospital. When she asked to leave, as Professor Stefan said, they said no, over and over. There was a mix-up with the paperwork, and so they gave her some paperwork, and she signed, and suddenly she was voluntarily admitted. After she was raped, the Sixth Circuit denied relief because of how they put it, her decision to enter Western State voluntarily. And the third story I wanted to tell was Billy Bibbit. Billy Bibbit was a character, a great and tragic character in Ken Kesey's classic One Flew Over the Cuckoo's Nest, published 50 years ago this year. Billy Bibbit was on the ward longer than most anyone else, on Nurse Ratchet's ward. He was a young man. The reasons for his stay were never made clear, but the classic scene, and some of you may remember from the movie, Jack Nicholson, when Jack Nicholson realizes that he alone is committed on that ward and most of the patients are voluntary, he turns to Billy Bibbit and he says, "You, Billy, you must be committed for Christ's sakes." "No," Billy says into the machinery. "Then why? Why? You're just a young guy. You ought to be out running around in a convertible, bird-dogging girls. All of this." He sweeps his hand around him again. "Why do you stand for it?" And that question, why, is at the heart of Kesey's great novel, One Flew Over the Cuckoo's Nest. Why would somebody voluntarily commit themselves to that situation? But even more fundamentally, what does it mean to act voluntarily under a set of constraints? Now, I'm not a mental health expert, but I was happy to be asked to read this note and to weigh in on it. In the world that I inhabit, criminal law, there are no two more tortured concepts than consent and voluntariness. To find that an individual consented to some state action is ordinarily to absolve the state actor for explaining why they did that. Valid consent legitimates the exercise of power by the powerful over the powerless. And a couple of contexts that spring to mind as I read Ms. Hagan's note is the waiver of the right to trial and the waiver of the right to remain silent. Popular culture celebrates the criminal trial as the apex of our system. When the truth comes out and the adversaries, two evenly matched adversaries clash, and the truth springs full grown from that process. But of course, as we know, less than 5% of criminal cases ever reach that point. What happens to the other ones? Well, they depend on a consensual and voluntary waiver. They depend on the accused voluntarily consenting to a conviction. Which raises some interesting issues of what voluntariness means within a set of constraints. If you ever watch somebody plead guilty in a court in this country, you'll see the judge ask a series of questions to make sure it's voluntary, the waiver of the right to go to trial. And the judge will say, "Are you under the influence of any drugs or alcohol?" The judge will say, "Are you satisfied with the services of your lawyer?" And then the judge will say, "Has anyone threatened you to get you to plead guilty today?" The greatest response I ever heard was a client of mine standing next to me, notwithstanding the fact that we had gone over this ahead of time. And the judge says, "Anyone threatened you to get you to plead guilty?" And he said, "Hell yeah, she did," pointing to the prosecutor. And of course he was right. And the other context more familiar to me is the context of interrogations and the right to remain silent. And we all know that a statement that's made while in custody, in state custody, is only admissible in court if it's voluntary, and if now the police have given Miranda warnings and they have been voluntarily waived the right to remain silent. Now, of course, we also know that the police can obtain this consent by any manner of intimidation, trickery, isolation, coercion, any number of levels of coercion up to a point. And courts, of course, consistently uphold confessions given under coercive circumstances as long as the formalistic requirements of Miranda have been met. And so the formalism of that case has really swallowed the meaning of what it means to voluntarily consent to waive a right. Now, the case DeShaney was about many things. In part, it was about competing visions of society and what duties the state owes to the vulnerable among us. It was not certainly an easy case. And even though sympathetic to a broader reading of state liability, worried about the real-world impact of allowing these suits to go forward and where the slippery slope would end. But the majority opinion in DeShaney, which Ms. Hagan criticizes rightly, I think, as, in her words, unrelentingly formal, went pretty far and seemed almost to revel in the tragic facts of that case and in the court's unwillingness to yield to the impulse of natural sympathy. Instead, the court focused on this illusory and arbitrary distinction between action and inaction, and the court created an incentive for agencies such as Winnebago County DSS not to act. And not for nothing, as Ms. Hagan pointed out, DeShaney has very few supporters among anyone who have studied or written about it. There is a lot about Ms. Hagan's note that I admire. I don't have time to go into all of it. Her willingness to point out a legal fiction, which, as I mentioned, I think has ramifications beyond the mental health context into a broader understanding of voluntariness and consent. She describes the term voluntary as an artificial signifier, and I think she's exactly right. Her note is a thoroughly researched and rigorously argued piece of scholarship that aims to harmonize legal doctrine in a way that is beneficial to the powerless. it is no mistake that the first word of her title is sheltering. This is legal scholarship with a purpose. She also artfully navigates, in my opinion, the tension between two well-meaning groups of people who address these issues, one which I would characterize as rights-oriented and the other as treatment-oriented. And that is a thicket in the mental health world, and I think she does a nice job addressing that. She doesn't shy away from bold statements, and she proposes a realistic and nuanced analysis that I think is very helpful in determining what duties are owed to a patient with the formal status of voluntary. She wisely takes seriously Justice Cardozo's advice, which she cites in a footnote, to resist the temptation when the demons of formalism tempt the intellect with the lure of scientific order. And I'll close with probably the most famous part of DeShaney, which is Justice Blackmun's dissent, which hadn't been mentioned yet. Justice Blackmun's dissent is memorable for the language he uses, for the emotion he conveys, and quite frankly, for when he compares Chief Justice Rehnquist and the majority to those judges that decided Dred Scott in the fugitive slave cases, and their exaltation of formalism over justice. What Blackmun said is that faced with the choice, I would adopt a sympathetic reading, one which comports with dictates of fundamental justice and recognizes that compassion need not be exiled from the province of judging. Ms. Hagan's note is not only well-researched, powerfully argued, and beautifully written, it is, in my opinion, a compassionate piece of scholarship. And for that, I'm very grateful, and I'm very excited to see what she does next. Thank you.